Good afternoon. We are going to resume our sessions. Good afternoon, Mr. Posner. I would appreciate if you could read the statement you have in front of you. If you don't have it, we will give it to you. The statement as a witness. Can you give it to him?
He'll have them in front of him in just a second. Thank you.
Would you mind?
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Posner. Mr. Foster.
Thank you, Mr. President. Mr. Posner, I believe you have reviewed the three statements you have submitted in this arbitration dated June 22nd, 2009, October 23rd, 2009, and March 22nd, 2011, correct?
Yes.
And do you ratify each of these statements and affirm their truthfulness before the tribunal?
Yes.
Now, respondent and respondent's damages expert, Dr. Spiller, says that on the eve of the Lesivo resolution, FVG was a distressed company that had never made a profit and was worth nothing to anyone. Will you please give the tribunal your evaluation of the financial condition of FVG and its cash flow generating capacity immediately prior to Lesivo?
Well, first of all, I would certainly dispute the statement that we were a distressed company. First of all, the company was backed by RDC as the principal investor, but more to the point, if you exclude the funds that were diverted by FAGWA, we were actually cash flow positive. And I think that's an important point to make. A couple of other things I want to mention are that from a management perspective, we had succeeded in achieving an industry key indicator, which is quite important, which is that we had operated for 1.5 years with no personal injuries. That measure is a good indication of your ability to manage, and more importantly, it reflects if you're running a safe railroad, you're providing good service, you're more likely to be growing the business and becoming profitable. Equally, I think it's important to mention that we had a number of real estate deals in the pipeline, ranging from additional electricity distribution projects with Jasur to a parking lot project in Gerona, and even a supermarket project with Unisuper.
Dr. Spiller also computes his weighted average cost of capital by, among other things, assuming that FVG would borrow money in Guatemala at 18.67% interest rather than borrowing money through RDC at 7.08% interest. Did FVG ever intend to finance any significant portion of its operations from borrowing in Guatemala?
No, because we could borrow at substantially lower rates from the USA.
How long have you been in the railroad business, Mr. Posner?
Since I was a sophomore in college, which would have meant since the summer of 1975.
Has RDC ever had an operating railroad investment that was not profitable after a few years of investment, restoration, and operation?
No.
Have you made profitable railroad investments in dilapidated railroads in third world or developing countries?
Yes, we were investors in Mozambique and Malawi in the Nacala corridor. We are investors in Argentina in two railways, ALL Central and ALL Mesopotamico. We are investors in the Central Railway of Peru, and I would describe all of those as fitting that description.
Have you also made profitable railroad investments in the United States?
Yes, our flagship railroad, the Iowa Interstate, which was depicted this morning, generates approximately $100 million of annual revenue, is quite profitable, and is continuing to grow. It's our flagship.
Has the Iowa Interstate also won awards?
Yes, we won the Gold Harriman Safety Award twice in recent years, which is the highest honor for railroads in the USA.
Do you receive inquiries from throughout the world asking you to make investments in dilapidated railroads and provide the expertise to renovate and operate them?
I'm sorry, I have an objection to that question. I'm not entirely sure what the relevance is to these proceedings of any such offers.
They've alleged that we don't know what we're doing and that we did a bad job in Guatemala. And the recognition of this company as one of the leading railroad companies in the world is certainly relevant to that question.
Go ahead. Reply to the question.
Yes, we're contacted quite often about railroads in other countries. Matter of fact, one of the things we're looking at right now is a 3-foot gauge mountain railroad in Latin America.
Respondent also criticizes the quality of FVG's rehabilitation of the railroad assets, which FVG got from FEGUA as a result of the usufruct contracts. Please comment on that claim.
Well, just let me start by saying that Guatemala is a country that did not have a railroad when we got there, and that the possibility of an expert existing in Guatemala was by definition remote. But I think some historical context is in order, because the era of private sector railroad management in Guatemala ended in the 60s when IRCA was nationalized. And so from a management perspective, there were actually 2 generations separating the last private sector operation of a railroad in Guatemala from when we came on the scene. So I think the ability of anybody from Guatemala to describe themselves as a railroad expert is not possible. But one of the other things that I think is worth mentioning is, now that we're using the word railroad expert, we went out of our way to induce world railway experts to come and visit our railroad. We would run an annual trip with our steam locomotives, and as a result of that, we were able to get visitors from literally all over the world who were railroad industry experts to come and take a ride on our famous narrow gauge mountain railroad. The price of the ticket was they had to give us a report on how they thought we were doing and what they thought we could be doing better. So, we recognized that we didn't have all the ideas, and so we did an outreach program to try to get world experts to come down. And there were 2 results. One was they confirmed that we were doing a good job, but also we got some good ideas. So we were constantly trying to achieve global best practices, to the extent you have global best practices for that environment.
Is one of those visitors going to testify in the next day or 2? Lou Cerny?
Yes, Lou Cerny actually is known as the Yoda of railway engineering. He's literally the world's foremost authority on railroad bridges, and he was the guy who first mentioned the words Guatemala, because I remember reading one of his articles in the American Railway Engineering Association magazine about 20 years ago.
Thank you, Mr. Posner. Answer any questions that Mr. Orta might have for you.
Mr. Orta, it's your turn.
Yes, might I have 1 second? I just want to make sure we have the notebooks.
Yes.
Bear with me. Chairman, we're just getting the documents up. There are a number of issues that we may discuss, and so we were over-inclusive in terms of the number of documents, but don't let the mountain of paper scare you. We are going to live within the hour limitation that you've set.
I was going to suggest that next time we put it on a Kindle or an iPad. It will be easier. They're going to bring a couple of backs in.
I think we're ready, Mr. Chairman.
Okay, go ahead.
Good afternoon, Mr. Posner.
Good afternoon, Mr. Orta.
How are you today?
Ready.
All right, excellent. Let's hope I'm ready too. I understand you're from Pittsburgh, correct?
Yes.
And as you mentioned to the tribunal, you have been involved in the railroad business for quite some time?
Yes, since the summer of 1975.
You have a passion for railroads?
I do.
I noticed in one of your declarations you mentioned that you acquired a steam engine from China and brought it to the United States. Is that right?
Actually, 2 steam locomotives.
Okay. And was that a personal acquisition, or was that something that you did on behalf of RDC?
As part of RDC's activities, I mean, to answer the question, yes, it was done by RDC. One of the things that RDC does is take an active role in railway preservation and culture, and this is one of the many projects that RDC's been involved in that reflect that.
And so, sir, you recognize the importance of preserving railway assets?
Yes, I do. I am committed to personally committed to railway preservation.
Let me show you, put up on the screen, please, Mr. Posner's third declaration, the first annex. Kelly, can you turn that around? Oh, that's not you. A little hard to read that way, unless we all turn our heads. Okay, that'll work. All right. Now, sir, this is Annex 1 to your third declaration in this proceeding, correct?
Yes.
Okay. You have a paper copy of it in front of you. You can just refer to the paper copy if you'd like. In 2000, did you have a profit or a loss? Based on what you report here in Annex 1.
Loss.
Okay. Of how much?
Approximately 6 million quetzales.
Okay. How about 2001? Profit or loss, and how much?
A loss of 3.4 million quetzales.
Okay. How about 2002? Profit or loss, and how much?
Loss of 5 million quetzales.
How about 2003?
Loss of 1.9 million quetzales.
2004?
Approximately 1.1 million quetzales loss.
Sorry, is that a loss, or is that supposed to be a positive figure?
I'm sorry. I'm sorry, you're right. It was a profit.
Now, is that a profit or is that revenue?
It's a profit.
Okay. How about 2005?
3.2 million quetzales loss.
Okay. And 2006?
6.1 million quetzales loss. The only thing that I would like to emphasize here is that these statements are in quetzales.
Right. And
Okay.
these are numbers that reflect, as you point out in Annex 1 in the title, what the actual numbers would have been had you received the trust payments that you claimed FEGWA owed you, right?
Yes.
So the actual performance was worse in terms of less revenue or higher losses than what is actually reported on this annex. Is that correct?
Please give me a minute to study these so I can refamiliarize myself with the annex, because I want to make sure I give you a appropriate answer.
Posner, if you'd like, we can just move on to the next issue.
Okay, the reason I'm hesitating is because there's something about these numbers that, something about them that I don't recall, but let's move on. We come back to them.
Okay. I think we established back at the jurisdictional hearing, when you agreed to participate in the bid for the railway restoration contract, you agreed to abide by all Guatemalan laws that were in effect at that time, correct?
Yes.
And the same when you agreed to participate in the separate public bid for the railway equipment?
Yes.
And you meant it. When you say you agreed, I mean you honestly wanted to comply with all Guatemalan laws that were in effect at that time.
Yes, and we did comply with Guatemalan law at that time.
Now, in relation to the bid for the railway equipment, you recall you participated in a bid back in 1997, November of 1997, for the initial railway equipment contract that you had?
Yes.
And that ultimately led to a signing of a contract in March of 1999? Or thereabouts, if you don't remember the precise date. We can show it to you if you'd like.
Yeah, if you could show me that, that would help jog my memory. I'd appreciate that.
Okay. It is document number C25, I'm sorry, bear with me. What? Yeah. No, the contract itself. No, 41? Well, the bid is C17, and the contract itself, bear with me. Maybe make this easier since we're limited with time while we're looking for it. The date is not as important as the question. You remember you entered into a separate contract for the railway equipment?
Yes.
And that resulted from that initial separate bid that you participated in, correct? For the railway equipment?
Yes.
And you put in a separate offer to obtain the railway equipment when you participated in that separate bidding process, as part of that bidding process?
Yes.
Okay. And ultimately, you signed the contract number 41 that's up on the screen, and that agreement never came into force or into effect, correct?
Not correct. It did come into effect as far as we were concerned.
Okay. Let's put up contract 143. As we're looking for this contract, do you recall that one of the essential requirements for this contract to come into force was that the contract needed to be approved by the President and his cabinet?
No, I don't recall.
Okay. Let's go to, sorry, go back to contract 41. Sorry. All right, and go to, I believe it's clause 6. Oh. Yeah, you got to go up to the body of the document. There we go. Now, okay, there we go. All right, so you read some Spanish?
Yes, I may ask for help, but I've got a pretty good knowledge of Spanish.
Okay. Rough translation, the document says that the term of the contract will be for 50 years and will begin to run 30 days after the publication in the official gazette of the Acuerdo Gubernativo or executive resolution through which this agreement is approved. Is that fair? Fair reading?
Yes.
And so the agreement would not come into effect, its term would not begin until there was an executive resolution approving the contract, and that was published in the official gazette, correct?
Okay, please repeat your question so I can give you make sure I understand what I'm saying, replying to.
The agreement would not come into effect unless and until it was approved through an executive resolution, which was published in the official gazette. That's what that clause says.
Okay, my technical legal Spanish is not good enough to interpret this, so I'm going to have to respond, I don't know.
Okay. You ultimately, though, entered into a separate equipment contract, right?
Yes.
And part of the reason you did so was because the prior equipment contract wasn't in effect, wasn't in force.
No. As far as we were concerned, it was in force.
Okay. Let's put up contract 143, please. Okay. If you could, Kelby, go to the initial text. Bear with me right there. All right, go to the next page, please. Next page. Next page, sorry. Okay, here we go. Okay. Go ahead and start with the word by, and if you could, Mr. Posner, we're also going to put it up on the screen for you. Just sort of do the, I don't know, next 7, 8 lines. A little lower. Okay. You got to get a little more text there, Kelby. I'm sorry. If you could, while he's doing that, if you could read the text. This is the English translation. Okay, and this document says that the Contract 41 did not take effect because it had not been approved by the President of the Republic.
But the rest of the sentence says, even though that was an unnecessary requirement, et cetera, et cetera.
Okay. But it was in the bidding terms that you agreed to, right? In other words, the requirement for government approval was in the bidding terms. And you agreed to that when you agreed to participate in the bid and accept the bidding terms.
I do not recall that detail, so I'll have to answer, I don't recall.
Okay. We could show you the bidding terms, but I think you previously testified to that in the jurisdictional hearing. So rather than do that, let's move on. In relation to this contract 143, you agree this was signed 6 years after, or 6 years after the original bid that you participated in for the railway equipment, correct? Between 1997 and 2003?
Yes, more or less.
And you did not do a separate public bid for this contract, did you?
I'm sorry, I don't understand your question.
You didn't participate in a separate public bid when this contract was signed in 2003?
I don't recall.
As you sit here today, you don't recall if there was another bidding process in 2003 for this contract?
To be honest with you, no, because there were several contracts which evolved from our original deal, and this was one of them.
Do you, okay, fair. With respect to executive approval of this contract, did you ever receive executive approval of this agreement, 143?
I don't recall.
Did you ever receive executive approval of contract 41?
No, we did not, because what's written in this agreement is that it says it was not approved by the President of the Republic.
Did you ever speak with your lawyers about what remedies you might have in relation to obtaining approval of contract 41?
As I recall, there were many complex discussions over the years with FEGWA.
I asked about your lawyers.
Okay, well, if you could
In that
please
case, I
repeat the
object.
question.
You're asking for invasion of the attorney-client privilege.
Well, did you ever inquire as to whether there were any remedies, legal remedies available to you in Guatemala associated with a non-approval of contract 41?
Objection if it calls for what his lawyer told him.
Question asked if he inquired.
Just reply to the question, please.
Okay, please ask me the question once more, and I will give you a yes or no.
Did you ever inquire as to whether there were any remedies associated with the non-approval of contract 41 under Guatemalan law?
No, to the best of my recollection, because that was being handled at the local level with FEGWA.
And when you say it was being handled at the local level, you mean by other persons who were representing you?
For a negotiation of this type, it typically would have involved our general manager and our legal counsel.
And your general manager at the time was Mr. Sen?
Yes.
Okay. Turning to another topic, in relation to the allegation you've made in this case that the government was in some way trying to take your concession to give it to Mr. Campoyo, do you have any evidence, as you sit here, that Mr. Campoyo today has any rights in your usufruct agreement, be it the 402 railway agreement or the rail equipment agreement?
Could you please repeat the question?
Do you have any evidence, as you sit here today, to prove to this tribunal that Mr. Campoyo or anyone on his behalf has any rights in your usufruct agreements in Guatemala as you sit here today?
I can't answer that question because that's a conversation between Mr. Campoyo and the government.
Right. My question is, do you have any evidence that shows that there have been any such conversations?
As I recall your question, you were asking me, do I know if there's anything in place today? And I don't know what might be in place today.
Right. So the answer is you have no evidence of anything being in place today, correct?
Yes, I have no evidence of there being anything in place today.
Okay. And do you have any evidence of Mr. Campoyo ever having gone to the government to tell them that he wanted the government to take away their concession so that he could have it? Take away your concession so that he could have it?
Yes.
You do have evidence?
Yes.
What is it?
Among other things, the meeting that I was at with the President of the Republic, in which Mr. Campoyo's name was mentioned.
Okay, why don't we take, you did some minutes in relation to that meeting, correct?
Yes.
Yeah. So we're going to direct you to those meeting notes, which are C-57. Yes, C-57, I'm sorry. And we also have it up on the screen. Okay. Now, sir, first of all, this is document C-57. It was provided by you and your team. In this case, these are meeting notes that you prepared after the meeting with President Berger in March of 2006?
Yes.
And just to set the stage, this is a meeting that you requested to have with the President?
No, we did not request the meeting.
Okay. Did the President request the meeting with you?
No, the meeting was requested by our partners, Cementos Progreso.
Okay. And what was the purpose of the meeting?
The purpose of the meeting was to explain to the President the current situation and potential situation for the railway company.
Okay. And based on your knowledge up until this time, had Mr. Campoyo threatened to take away your concession by this point?
Yes.
Okay. And in the meeting, did you tell the President that Mr. Campoyo had threatened to take away your concession?
No, I did not.
And that's not reflected anywhere in these meeting notes, is it?
Yes, it is reflected because Mr. Campoyo's name is in these notes.
Well, his name is in the notes, but let's read what it actually says. What it says, based on your notes, is that there was a comment made by Arturo, who I assume is Arturo Gramajo, the overseer of FEGWA at the time?
Yes.
And your notes say that he commented that there was substantial interest of other private sector parties in the development of Ciudad del Sur, right? That's what that says.
Yes.
That doesn't say that Mr. Gramajo said that there was substantial interest of private parties in the taking away of your usufruct right, does it?
No, it does not, and I can see, with the benefit of hindsight, that what I should have written was
Well, I'm not
the
asking
South
you.
Coast.
I'm not asking you to rewrite the document, sir. I just asked you what the document, the contemporaneous document, says. That's all I'm asking. I'm not asking you to do a rewriting of the document. If you could go down a little bit further.
Could I just clarify what I just said?
I haven't asked you to clarify it. I think it was fairly clear. I'm asking you what you wrote down.
Well, I'd just like to make a point which I think is important for the tribunal, and that is to the extent that I'd be talking about a real estate project owned by Ramon Campoyo, that's none of my business. And taken out of context, what this really means is the development of the railway to Ciudad del Sur. And in that respect, I should have written it with those additional words, but did not. So I'd like to clarify that for the tribunal.
Now, if we look a little bit further down, you provided your personal observations on what you thought the President's reaction was to the meeting, correct?
Yes.
And you say, at the time, that your personal observations are that the President is genuinely interested in seeing us succeed, correct?
Yes.
And that the follow-up is very much in your hands. Correct?
Yes.
Now, you did have, and you've testified in your declaration, that you had some discussions with a Mr. Hector Pinto about the railway service toward the south.
Yes.
Okay. And you recall, do you not, that Mr. Pinto sent a letter to you? I'm sorry, Mr. Campoyo sent a letter to you in which he commented that he had no further interest in having any negotiations with you or with FEG?
Yes.
Okay. R-173. Can you put R-173 up, please? Okay. Okay. This is a letter, a translation of a letter that Mr. Campoyo wrote to Jorge Sen on 15 April 2005, correct?
Yes.
And Mr. Sen was your general manager, the general manager of FEG of Ferrovias at the time?
Yes.
And in this letter, Mr. Campoyo says that he has decided not to participate in the railway project that was presented to me, meaning to him, in the city of Miami, correct?
Yes.
And he says that project, whatever it may be, was presented to him by certain officers of the company you represent, meaning Ferrovias, correct?
Yes.
You had seen a copy of this letter before today, right?
Yes.
And Mr. Campoyo is fairly clearly saying he doesn't want to participate in any railroad project here, correct?
Yes.
Now, Mr. Sen sent a response to this letter, didn't he? Let's put up R-174, please. You've seen this response before?
Yes.
And in it, Mr. Sen, on behalf of Ferrovias, responds that acknowledging receipt of Mr. Campoyo's letter, right?
Yes.
And acknowledging that Mr. Campoyo informed Ferrovias that he had decided not to participate in the railway project, correct?
Yes.
And he confirms that it was a railway project that was presented to Mr. Campoyo in Miami by Ferrovias.
Okay. Please ask me that question again, because I want to give you a specific reply.
Well, sure. The letter says, I hereby acknowledge receipt of your correspondence dated this past April 15, in which you inform us of your decision not to participate in the railway project that was presented to you in Miami by our company, correct? Did I read that right?
Yes.
So he's talking about a railway project that was presented to Mr. Campoyo by Ferrovías in Miami.
Yes.
By this point in time, is it your testimony that Mr. Campoyo had threatened to take away your company, your concession?
Yes.
Okay. Can you explain to us why Mr. Sen doesn't say anything about that in this letter?
I can't comment as to what Mr. Sen would have been thinking, but it would seem to be impolitic in a letter of this type to reference threats. If I were writing this letter, I can't say I would have worded it any differently.
Okay. Mr. Sen does say in the second paragraph that we, meaning Ferrovías, regret your decision and understand your reasons, correct?
Yes.
And the decision you were regretting was his decision not to participate in the railway project.
Yes.
Now, after this, according to your testimony and your declaration, you received some additional emails from Mr. Pinto?
Yes.
Okay. Let me ask you, before we get into those emails, after receiving those emails, having received a letter from Mr. Campoyo telling you that he had no further interest in participating in the railway project, and he had decided not to participate in the railway project, did you reach out to Mr. Campoyo to ask him why you were still receiving communications from Mr. Pinto?
No, we assumed that Hector Pinto, as in the past, was continuing to represent him.
Did you receive any further communication from Mr. Campoyo instructing you that he had decided to reinitiate discussions about this project?
No, because Mr. Pinto is representing him.
Did you receive anything from Mr. Campoyo is my question.
No.
Did you receive a call from Mr. Campoyo where he said, I've reconsidered and I've asked Mr. Pinto to reach out to you about these issues?
Not to me, no.
Okay. To anyone that you're aware of?
Not that I'm aware of.
Okay. Now, in relation to the communications you received from Mr. Pinto, let's go to C-109, please. How much time do I have? Okay. This is a letter that's been provided in this case by your lawyers, C-109. And it's a letter dated February 28, 2006, purportedly from Mr. Pinto to Mr. Sen, correct?
Yes.
In this letter, first of all, Mr. Campoyo is not copied in this letter, is he?
No, nor would I expect to have been copied.
You were copied, though, right?
Yes.
And in the letter, he talks about expressing an interest. He says, my interest in connecting Ciudad del Sur to Puerto Quetzal. Right?
Yes.
He says it's his interest. He says my interest, correct?
Yes.
He doesn't say it's Mr. Campoyo's interest there, does he?
No, but we assumed it to be.
Okay. You made the assumption. I'm saying he didn't say that, though. He just talks about his own interest.
Mr. Pinto used Mr. Campoyo's project,
Right. That wasn't my
which
question.
is another way of saying that he was acting on behalf of Mr. Campoyo.
Well, you're making that assumption, right? That's an assumption you're making.
Yes, and under the circumstances, I think it was the right assumption.
Okay. But as I say, you have no knowledge whether Mr. Campoyo even knows that this letter was sent, do you?
No, and I would not expect that Hector Pinto would have told him about his weekly dinner plans.
Okay. In relation to the letter, what he's talking about here is obtaining information on the options of service, right-of-way lease, or transportation solution that Ferrovías can offer us, correct?
Yes.
He doesn't say here he wants to take away your concession, does he?
No, and nor would I expect that to be contained in a letter like this.
In fact, you don't have any letter where Mr. Pinto said he wanted to take away your concession.
No, and nor would I expect that we would ever get a letter to that effect
Okay.
from Mr. Pinto or Mr. Campoyo.
No one from the government is copied on this letter, correct?
Correct, and again, this is a pretty casual follow-up letter.
Let's go to C110, please. This letter, or this is an email, it appears, from Mr. Jorge Sen from Ferrovías to Mr., well, CCing Mr. Pinto, CCing yourself, and it looks like maybe being sent to the, an address associated with Mr. Pinto?
Yes.
And he's talking about, well, first of all, he's responding to Mr. Pinto's letter, correct?
Yes, he's responding to an email. I just don't know which email. It doesn't say.
Okay. And he's providing some particulars about the possibility of rail service in relation to providing rail service in relation to some aspect of Mr. Pinto's business.
Yes.
Okay. Nowhere in this letter does Mr. Sen say anything about any supposed threats to take away the usufruct rights, does he?
No, and again, I think it's highly unlikely that that type of discussion would be in a letter like this.
Okay.
I can't speak for Mr. Sen as general manager, but if I was communicating like this, I certainly would not have included the words threats or other things in this context.
Okay, put that up. Okay, we're going to skip a few here just to move along and go to C117. This is another document that has been put forth in your by your lawyers in this case. Now, just so that everyone's clear, Mr. Pinto is deceased, correct? To your knowledge?
Yes, to the best of my knowledge.
Okay. So all of these communications, obviously Mr. Pinto can't respond to any of these things. In relation to this email, this is an email that was sent to you?
Yes.
And in it, Mr. Pinto, assuming he sent this email, addresses the email to you, and the subject line, can you just interpret that for us in English, please? subject line, sir?
Yeah, the subject line is basically tariffs for the provision of freight transportation of sugar.
Okay. This is after the president of Guatemala has declared Lesivo your equipment contract, correct?
Yes.
And after the resolution, executive resolution was published?
I do not recall the date of the publication of the presidential resolution.
I mean, it's in the record, but I will tell you that it was published on the 25th of August, 2006. And assuming that representation is correct, you would be receiving this email after that, right?
Yes.
And were you also making the assumption here that Mr. Pinto was writing on behalf of Mr. Campoyo?
Yes.
Again, he doesn't copy Mr. Campoyo to this email, does he?
This is a request for a quote for freight transportation. If I were Mr. Campoyo, I'd be pretty upset being copied on something like this.
My question was he copied, to your knowledge?
No.
To your knowledge, did he ever receive a copy of this email? Has he ever seen this email to your knowledge? Mr. Campoyo, that is.
No, to my knowledge.
Okay. And in it, there's no comments of threats to take away your usufruct rights, is there, in this email?
This is a threat.
Can you explain where the threat is in this email? Because we're looking at the text.
This is a quite specific threat in that he's requesting prices for freight transportation on the South Coast Railway, which at the time did not exist.
Okay. That's the threat right there? I just want to make sure I understand what you're saying.
I took it as a threat.
Okay. And you took it as a threat to mean what? Exactly.
As I recall, the word I used was fishing expedition.
So the threat was that he was fishing, Mr. Pinto?
No, it was my belief, and I don't recall how I communicated it to my colleagues, but I do recall when I received this email, in context and the way this was constructed, was clearly intended to prove that we had somehow fallen short as far as the South Coast.
And you take all that from the text in this email?
Yes, I do.
Okay. Okay, very good. Other than this document and what some of the other documents I've showed you, again, there's no other piece of evidence that you can point to that the government ever spoke with Mr. Campoyo or Mr. Campoyo ever spoke to the government about taking your concession away, correct?
I forget the number of times that Mr. Campoyo's name was mentioned by government people. The one that I recall the most clearly was the meeting with the president, in which his name was mentioned at the meeting with the president. I remember that very clearly.
Good. And we discussed that already. Let's go to what document is this? I'm sorry. R321, please. Okay. I want to call your attention to, in this string of emails, an email that you received from Mr. Juan Pablo Carrasco de Groot, dated 11 August 2006, time of the email 5:51 p.m. Do you see that email?
Yes.
And he sends it to you and titles it Dear Henry.
Yes.
In it, he is talking about the declaration of La Cividad, correct?
Yes.
And toward the bottom, Mr. Carrasco says to you, they can declare the lascivity of the court resolution, so we will have to find out what it is they are technically planning to issue. In any event, or I'm sorry, in any case, the lascivity is not an automatic procedure. It's a process that indeed will be lengthy, since after the resolution is issued, the annulment of the contract must be approved by a court. You see that?
Yes.
On the 11th of August, you were being told that whatever resolution was going to be issued by the President was not an automatic procedure, correct? The lascivity is not an automatic procedure, he says.
Yes.
And that it would have to be approved by a court, correct? The annulment of the contract would have to be approved by the court.
Well, actually, it says approved by a court, and to me that suggests that at this stage we weren't even quite sure what we were dealing with. If it named the specific court, I would, the way I read it is, we're not quite sure what we're dealing with here, because it says it must be approved by a court.
Right. But he's telling you that it's not automatic, right? I mean, those are his words. I'm not making that up. That's what he said. Not an automatic procedure.
Those are his words.
And he tells you that the annulment of the contract must be approved by a court. Correct?
Yes.
Okay. He also tells you, interestingly, if we go down to the very last sentence, please, of that very same email, we are also working on the local and international legal proceeding that might be available to us, correct?
Yes.
So by the 11th of August, by the way, just to make sure that we have this right, Mr. Carrasco was your lawyer at the time, dealing with the problems with the government, correct?
Yes.
And he's your lawyer, one of your lawyers in this proceeding.
Yes, he's one of our best lawyers.
Okay. Kudos to him. But the point is, he's telling you at this time that he is working on international legal proceeding that might be available to you, to your company. Correct?
Yes.
So you must have authorized him to work on that at some point before the date of this email, correct?
Yes, his email came 3 hours after I sent the email that triggered the thread of conversation.
So you're saying you gave him that authorization 3 hours, within those 3 hours? Is that what you're trying to tell us?
No, I don't want to speak for Juan Pablo, but it looks to me like what he was doing was already the wheels were spinning, trying to figure out what was going on in the 3 hours since I had told him that there was something going on.
Okay, very good. What's that?
105.
Yeah. So is it R105? Can you put up R105, please? Okay. Yeah. Okay. So this is a document you've seen before, correct?
Yes.
This is a press release. Kelby, I don't know if there's a way to put all of the, there you go, thank you. There we go. I need to see the whole title. There we go. Press release issued jointly by RDC and Ferrovias, correct?
No, it was released by Ferrovias.
It's got RDC's name on it, doesn't it?
Yes, it says it's an affiliate of RDC.
Okay. And you are listed at the bottom as one of the contact persons, right?
Yes, though my name is misspelled.
And it also, right, you're Henry, you're not Harry, right?
Last time I checked.
Good. It has all your contact info here in the U.S., correct?
Yes.
And in it, first of all, it's dated August 28, 2006, correct?
Yes.
And that is the first business day after the government published the Declaration of Lesividad on the 25th of August, correct?
I don't recall the date of publication. The way I read this, which I assume is correct, is the declaration as opposed to publication of
Right. Well,
Lesivo.
if you accept for purposes of the question that on the 25th of August, the Declaration of Lesividad was published in the Official Gazette, I'm not asking you to confirm that, I'm just asking you to accept it, then this release was issued on the first business day after that, which is Monday, August 28, 2006, correct?
Correct.
Okay. Let's put up R327, please. If I could just ask the tribunal how much time I have left. Oh, sorry.
You have about 4 minutes.
Okay, thank you. Okay, thank you. Okay, Mr. Posner, this is a letter that you received from, if you could just put the person who sent it, please, Kelby, just scroll down a little bit. Okay, this was sent to you by Federico Melville, correct?
Yes.
And he was one of your minority, or is one of your minority partners in Ferrovias?
Yes.
Okay. If we could go up, please. This is dated May 2nd, 2007, correct?
Yes.
Okay. And this was sent just before you initiated this proceeding, this CAFTA proceeding, correct?
Yes.
And if we can highlight the first sentence, please. In the first sentence, Mr. Melville says that the purpose of this message as minority shareholder in Ferrovias is to let you know that we do respect your decision to pursue an international arbitration process against the government of Guatemala, but by no means we agree with it, correct?
Yes.
Okay, if we can go down a little bit. Let's highlight the entire last paragraph. Mr. Melville also tells you that the agreement we reached with the government of Guatemala in November 2006 was a good one, both in giving the business a reasonable chance of achieving an operational turnaround, as well as giving all parties a new opportunity to start over. You see that?
Yes.
And he further says, accepting a startup with a clean slate would have given all stakeholders a chance to be part of a success story and a benchmark case to the world, correct?
Yes.
And he further says, I am afraid that your decision to pursue litigation will mean we will have to forfeit this opportunity, placing Guatemala as a republic and its private capital in a very difficult position in respect to the CAFTA, correct?
Yes.
In this letter, he says nothing about the government taking away your concession and giving it to Mr. Campoyo, does he?
No,
And
nor
he
would I
says-
expect it.
And he says nothing in this letter about the government using the Lesivo Declaration as a means to coerce you into accepting some kind of deal, does he?
No, nor would I expect it.
He does say the government reached some kind of good agreement with you in November 2006, doesn't he?
Yes, but that's not correct. There was no agreement, and what was discussed was nothing like something we felt was good for the company. So I just want to highlight to the tribunal, when it talks about an agreement here, there was never an agreement.
The government did continue to negotiate with you after the Lesivo Declaration, right?
I would not characterize that as a negotiation. I characterize that as an extortion.
You characterize what as an extortion?
The discussions we had with the government
Really?
after the declaration of Lesivo.
Can we put up the minutes? If you just beg my indulgence 1 second, just to respond to this point. Can you please put up the minutes from the negotiations that took place after? As they're looking for the document I just asked for, did you ever send a letter to the government complaining about their extorting you after the Lesivo Declaration?
Did I personally send a letter to the government?
Yeah.
No, that was done through our management team.
Okay. Which letter are you referring to, sir?
Any discussions we would have had with the government were through our management team.
As we sit here today, and I'm fairly familiar with the record, I don't recall any letter wherein anybody on behalf of Ferrovias sent a letter to the government accusing them of extorting RDC or Ferrovias in any negotiation discussions. Do you recall such a letter having been sent?
No, I don't personally recall.
Okay. These are the minutes, and I'll end my questions here. These are the minutes in relation to the, what is this document? R36, in relation to the meetings that took place after the Lesivo Declaration. Mr. Sen was your general manager at the time, correct?
Yes.
Okay. And these are the minutes wherein you say, or these are the negotiations in which you say the government was trying to extort you.
Yes.
Okay. Well, the minutes speak for themselves. I would just ask the tribunal to take a look at those minutes in assessing that comment.
May I comment as to those minutes?
I haven't asked you a question about them, but your counsel may have an opportunity to do so.
Okay, thank you.
Yeah, so that I have no further questions at this point.
Thank you. The members of the tribunal have some questions. So, I'll change the first. Janet. You want to speak here? You have one over there. Maybe more convenient.
I'm sorry. Are the questions going to go before redirect, or are both counsel going to have opportunity to question after the tribunal questions?
We reserved the right of the tribunal in the procedural order to ask questions at any time. And of course, you would be entitled, both parties, to question on what the tribunal had asked.
Thank you, Mr. Chairman.
That would be the usual thing.
Mr. Posner, you said that prior to March 2006, you'd had a threat from Mr. Campoyo to take the concession or take the contract. What form did that threat take?
In March of 2005, we met with Hector Pinto, Ramon Campoyo's guy for the railway business, at the Marriott in Guatemala City. And at that meeting, there was discussion of the basically a deal whereby we would be allowed to remain shareholders in our business in exchange for handing over 50% of it to Mr. Campoyo. And as part of a sidebar discussion, we were told that if we didn't agree, they'd take it. Or, I'm sorry, we will take it. Sorry. We will take it.
Being Mr. Pinto.
We being the Campoyo group as represented by Mr. Pinto.
But they never took it.
They did not take it.
Thank you.
If I could I just follow up on that? They didn't take it in that context, but there were follow-on threats, indications that something was going to happen, and the end result of that was lesivo. I should have spent more time answering that question.
Mr. Posner, I understand that there was a meeting of April 23rd, 2001, in which Mr. Campolo invited you and Mr. Dugan to a meeting. Do you recall that meeting, and can you describe it?
That was an introductory meeting at his house. It was in the evening. It was after hours, but before dinner, and it was basically a get-acquainted session in which we were introduced to him as somebody who was interested in a wide variety of businesses on the South Coast, including the railway.
At that meeting, did he express an interest in gaining control of the railroad?
As I recall, he signaled that he was not somebody who liked to do business with partners, but we didn't get into that detail of a discussion. Hector Pinto was there, Bill Duggan was there, and as I recall, our general manager was also there.
What evidence do you have that Mr. Pinto represented Mr. Campolo?
The first evidence was that we met him at Mr. Campoyo's house in 2001, and he was introduced as Mr. Campoyo's representative. There was a follow-up meeting in Miami in which Bill Duggan met with him. Various meetings involving Hector Pinto with us, the mention of Ramon Campoyo by name in the meeting with the president, a long list.
Did Mr. Campoyo himself indicate to you in your presence that Mr. Pinto was his representative?
It was made clear to us in 2001 that he was his representative for the South Coast, because that was really the introductory meeting that kicked off all the discussions that followed in the subsequent years.
This is something Mr. Campolo himself said in your presence?
You know, to be honest, I don't recall all the details of that meeting as far as the exact conversation, but it was made clear to us that Mr. Campoyo was relying upon Mr. Pinto for railway-related matters, and certainly their actions after that supported that.
After the Lesividad, which was appointed at contracts 143, 158, you continued to have your deed 402, which was not the subject of Lesividad, and there's at least an indication in some of your company's records that you considered 402 to be the more valuable of the two deeds. Is that correct?
Well, not really, because you can't have a railway without rolling stock, and the two were like Siamese twins. You can't have a railroad, you can't have track without rolling stock, you can't have rolling stock without track. So they were, economically speaking, they were joined at the hip. it's really, from an economic perspective, very difficult, if not impossible, to separate the two.
When the Lasividad declaration was issued, was there any consideration given to the fact, rather than issuing the press release the day after, of just simply continuing to operate under 143, 158, and 402?
We tried.
Could you describe that and what the results of the efforts were?
Well, in the first several weeks, we were trying to figure out what was going on, and we were trying to do really three things all at the same time. One was to run the railroad. The other was to manage our finances, given that all of a sudden we found ourselves getting cut off by suppliers and customers. And the third was to deal with lesivo, which was a word that we'd never heard. So we're trying to do a lot all at once, and it was very difficult.
But I'd like to have a better understanding, since you indicated these two were very intimately tied. You published this press release the day after the lesivo, announcing to your customers basically that as a result of the lesivo, you were going to have difficulty operating. Why did you make that decision the day after rather than wait and see what the effect of the publication was on your actual ability to operate?
Well, it's tough to reconstruct exactly what we were thinking blow by blow, but at the time, this was big news. The president was saying on national television that we were finished, and we felt that we needed to communicate something that was, I like to use the word measured response, to let not just our customers and creditors know, but we had shareholders. And also, this is a very interesting story, and at the world level, nobody's ever taken a national railway and put it back in operation for an abandoned state. So it was a measured response on our part in an environment where, at the same time, the government was sending out all kinds of signals that they were coming after us. So we felt we needed to do something, and that press release was the something that we did as a measured response intermediate step.
Can you tell us what your understanding was of the railroad's obligations in terms of phases 2 through 5, and under what circumstances and conditions you were to be able to proceed after you rehabilitated phase 1, the North Atlantic?
Yes, our obligations were to initiate work on those phases and to build them out as market conditions permitted. And we have signed letters from FAGWA to the effect that we had initiated the work for phase 2, and that as far as phase 3 was concerned, that we had demonstrated that the commercial reality at that instant did not support initiation of that work. But it was clear from the economics of the deal that the additional phases were contingent on market conditions, and that we would build them out in conjunction with other investors as conditions permitted, and that's what we did.
Did Mr. Gramajo in 2005 indicate, I think through a letter, that he felt you were in compliance with your further obligations on phase 2? Do you have any recollection of that? And more broadly, did the government ever indicate to you that they felt you were in violation of your obligations under the future phases beyond phase 1?
It's kind of hard to remember all the correspondence with Arturo Gramajo. I'd rather answer that part of it with the I don't recall. But as far as the signals from the government, up until the time of Lesivo, they were, there was no indication that they were up to what Lesivo turned out to be. It was a complete surprise to us, and like I said before, I'd never heard the word Lesivo until it was being declared.
Do you take the position that in terms of leasing the rights of way, which was certainly a valuable part of your concession under 402, that in order for that to be valuable, you needed to have the railway operating in that part, or could you independently lease the right of way in the south, even though the railway wasn't in operation?
We were free to develop the right of way for whatever economic purposes we could develop, be that rail operations, pipelines, electricity distribution, industrial roads, leasing of stations, etc. It's a common business for railways.
And have you done so?
We had some deals in place, and we had more in the pipeline, but since the declaration of Lesivo, we have not been able to do anything more.
How soon after the Lesivo was published did your customers and suppliers begin to express concerns about continuing to do business with you?
The next working day.
And you continue to this day to have control of the equipment under 143 and 158?
That's a good question. The physical reality is that the rolling stock has been marshaled into the shop complex in the center of Guatemala City, kind of in a circle the wagons mode. Literally, the railway itself has been stolen. If you can imagine a steel trestle 150 feet high disappearing segment by segment, this is a world civil engineering monument. And if you could imagine those scenes in Peru, which were shown in the original, imagine those bridges disappearing segment by segment. Literally, there's nothing left. The railway is being stolen.
I understand you personally may not be involved in all of these negotiations that Mr. Sen, and we'll have time to talk to him about this, but the Lesivo declaration with respect to 143 and 158 was on two precise issues, as I understand it. The lack of a public bid and the absence of presidential and cabinet level approval. Is that your understanding?
Yes, more or less. I'm not a lawyer, so I should probably give you a more precise answer, but those are
what I'm
two
trying to
key issues.
understand is if those were the two precise issues, why was it necessary to have 2 years of negotiation? What is it that you understood the negotiations were about if those were the two precise issues, simply rebidding and then getting presidential approval? Why couldn't that have been agreed to promptly? What was the nature of this 2-year negotiation, 2004 to 2006, that was taking all this time if those were the two precise reasons for the Lesivo declaration?
Well, as I understand it, the government kept coming back and saying there are these technical problems with what we'd already agreed to and what we were functioning under, and we needed to work together to solve them. And so, at the government's request, we entered into these subsequent agreements which were intended to fix their problems.
That's a very general answer. I'm really trying to understand, again, these were two very precise issues that seems to be easily resolvable. Now, we hear statements about $50 million being demanded. I mean, was this all part of the mix? Were these being put into the discussion about 143 and 158? Try to illuminate the tribunal on what the nature of these negotiations were, whether they were mixing in 402 obligations for developing the South Coast, or were these limited to what became the La Ciudad focus, which was 143 and 158?
Well, as I recall, and I would ask my colleagues to respond when it's time for them to talk about this as well.
Let me ask what you knew. That's
Okay. So let me give you a very simple answer. It was a never-ending story and a continuous swirl of micro issues which did not have a major impact on the economics of our deal, but which the government said was important to them, and so we entered into this second and third negotiation because they asked us to. And eventually we got to the era of La Ciudad.
one last question, I'm sorry. The respondents have put up some charts indicating that you were losing money up to the point of La Ciudad. Illuminate us as to what would have led to a burst of profitability in later years.
Well, we were actually making money if you add back the money that was diverted from the infrastructure trust. And on the eve of La Ciudad, there were a number of real estate projects in the pipeline. You know, these projects usually take multiple years to develop, and just to name a few, there was a supermarket company, there was some urban parking opportunities, there was more electricity distribution by people who would pay, and other similar things. It was a portfolio of opportunities, all of which require multiple-year gestation periods. But more to the point, we were optimistic about the future of the company.
Mr. Foster, as both on the questions of the tribunal and redirect, and then I will ask you on the questions of the tribunal. For the record, when I said you, I refer to Mr. Orta.
Thank you.
Thank you, sir. Following up on one of Secretary Eisenstadt's questions, Mr. Posner, when the government was talking about the alleged technical problems with the deeds, in that same conversation, were they asking you to put up more money to invest $50 million?
No, that came later. That was a parallel discussion.
But when they declared, his specific question was, when they declared Lesivo on two very specific grounds, were they at the same time demanding that you put up $50 million?
At the same time that we were dealing with these equipment contracts, et cetera?
When they declared Lesivo, stating that, this is Secretary Eisenstadt's question, when they declared Lesivo, asserting two specific grounds for Lesivo, were they at the same time asking you to put up $50 million?
Yes, and they put a deadline on it also. It was basically commit immediately to spending $50 million or you're out of business.
And was there any requirement in the contracts that you had with the government that you had to put up this $50 million?
No.
And at the same time the government was asserting these two very specific reasons for Lesivo, were they also demanding that you pay more money under Contract 402, telling you that they weren't getting enough money out of Contract 402?
That was part of the discussion.
And were they also, at the same time they were asserting these two technical grounds, were they demanding that you drop your local arbitrations?
Yes.
Now, Mr. Orta asked you some questions about your commitment to abide by the laws of Guatemala. When you committed to abide by the laws of Guatemala, did you expect them to be applied without discrimination, without arbitrary action, and with due process?
I'm sorry, I'm going to I mean, that is a very leading question. I understand this is, I mean, this is his lawyer asking questions here.
Could you rephrase it, please?
Okay, I'll put it in the opposite so you can answer no to it. Did you, so it won't be leading, did you expect that the laws would be applied against you discriminatorily?
Certainly not.
Did you expect the government to take arbitrary action with regard to you?
No.
Did you expect that you would be accorded due process of law?
Yes.
We saw some documents concerning the Ciudad del Sur project, and Mr. Pinto was writing you about the Ciudad del Sur project. Who owned Ciudad del Sur?
Ramon Campoyo.
When Mr. Pinto contacted you concerning Ciudad del Sur, did he tell you who he was acting for?
He didn't need to. Ciudad del Sur was Ramon Campoyo's project.
Okay. Now, Mr. Orta also showed you a document where Mr. Carrasco told you that La Ciudad was not automatic and it had to be approved by a court. That document was dated August the 11th, 2005. When you got that document, 2006. When you got that document from Mr. Carrasco, did you know the reaction that your customers and suppliers and your prospective lessees were going to have when Lesivo was declared a couple of weeks later?
We had an idea, which was that we were in for big trouble.
And when Mr. Carrasco de Groot was telling you he was investigating international legal proceedings, do you recall what was the international legal proceeding that he was talking about?
No, I don't, and that's probably because it was so new that we had no idea. I mean, my communication with Juan Pablo was probably an hour after I had the conversation with Federico Melville, so we really had no idea what we were dealing with.
You mentioned you were asked about a meeting that you had with Mr. Campoyo. Secretary Eisenstadt asked you about a meeting you had with Mr. Campoyo on April the 23rd, 2001, and you also mentioned another meeting that you had with Mr. Campoyo on December the 4th, 2004. At the meeting in December 2004, this was with I believe this was Mr. Dugan. Was that meeting reported to you by Mr. Dugan?
I believe so.
And did Mr. Dugan report to you any statements that Mr. Campoyo had made concerning his interest in the railroad?
I don't recall.
Did Mr. Pinto, out of the presence of Mr. Campoyo, ever say to you that Mr. Campoyo would take the railroad business away from you?
Could you repeat that?
Yes. Did Mr. Pinto, whether or not in the presence of Mr. Campoyo, did he ever say to you that if you didn't make a deal with Mr. Campoyo, that Mr. Campoyo would take the railroad from you?
Yes.
When you wrote in your notes after your meeting with President Berger in March of 2006, that you thought that the president was generally interested in seeing you succeed, did the president at that meeting tell you that Dr. Gramajo had already sent him communications asking him to declare the railroad usufruct lesiva?
No. That would have been shocking.
No further questions, sir.
Thank you. Mr. Orta, on the questions of the tribunal.
Yes, sir. Thank you, Mr. Chairman. Could you put the press release back up, please? Thank you. And just for the record, this is R105. If you could just highlight, let's see here, bear with me. Dan, the part about the customers? There we go. I think it's the third paragraph. Left-hand column, third paragraph. In this press release, sir, that you issued the day after the Lasivo declaration, you say, in the short term...
Excuse me, Mr. President, I'd like to object. Mr. Orta continues to say that the press release was issued the day after the Lasivo resolution. I think it shows on the side, which has just been covered up, I think it shows on the side that it was actually published on September the 4th. You can see it written in a horizontal fashion.
Well,
I'm sorry, a vertical fashion. It was actually published, so it's September the 4th. It's not the day after the Lasivo resolution.
well, let's clear that up. This copy of it is published. It appears on the 4th of September, but the document itself is dated the 28th of August 2006, right?
Yes.
And that's when it was released, correct?
I don't recall.
Is there any reason you would be backdating a press release?
I can't think of one.
Okay.
That would be dishonest.
Okay. In relation to the third paragraph, left-hand column, it says, in the short term, under the terms of the usufruct, the government cannot force the company out of business. However, its actions have placed greater pressure on FBG by making its customers and suppliers wary of continuing to do business with it. Do you see that?
Yes.
And this is something that you sent to your customers and suppliers, correct? That's who it's addressed to in part.
Yes.
All right. In relation to these questions that were asked about the $50 million demand, let's put up C-131. Actually, okay, so this is a newspaper article, correct?
I don't see anything on that page that talks about us.
Okay. Go down, please. All the way down. Okay. You see that? Do we have the English version of this? Okay. Just let's show the date for a second, please. This is dated September 5th, 2006. Assuming the English format for using dates. Excuse me?
Objection. I don't believe this responds to questions from the tribunal.
Oh, he was asked about the $50 million demand by Mr. Eisenstadt.
Okay, please repeat the question.
Yeah. So this is dated September 5, 2006, correct?
Yes.
All right. And this is the document that, wait, is this the right doc? Yeah. This is the document that your counsel rely upon for this notion of there being some $50 million demand being made by the government. My question is, do you have any other document that supports that allegation?
I don't know.
You aware of any other document that supports that allegation that has been produced in this case?
I don't recall.
Okay. This is after the press release, the dated press release, correct?
Yes.
And this is after the government issued the Lasivo Declaration and had it published in the Official Gazette, correct?
Yes.
And this is, just so that we're clear, this is a newspaper account of of statements that supposedly were made by President Bourget, correct?
Okay, could you repeat that question?
Yeah. This is a newspaper account of statements that supposedly were made, or of a conversation with President Bourget, better characterized.
Yes.
And the information there about the $50 million demand, that is a reporter's characterization of a conversation he had with Mr. Bourget, correct?
I don't know. I didn't write the article.
Okay. There are no quotes around that, around that statement, are there? Attributing that directly to President Bourget?
No, there are no quotation marks.
You mentioned in response to questions by Mr. Eisenstadt about the December 2004 meeting, correct? There was a December 2004 meeting with Mr. Campoyo, I think you were asked about?
Yes, and that's a meeting that I did not attend.
And my question goes exactly to that. You, in your response to Mr. Eisenstadt, said that Mr. Pinto was at that meeting, correct?
No, what I said was that Mr. Pinto was at the 2001 meeting at Ramon Campoyo's house.
Okay, maybe I misheard you, but to your knowledge, Mr. Pinto was not at the December 2004 meeting, was he?
I don't know who was at that meeting. All I know is that I wasn't there.
Okay. Mr. Duggan would be a better person to be able to answer that question.
Yes.
You mentioned, in relation to questions from Mr. Eisenstadt, you mentioned about some potential real estate deals that you said would take multiple years to develop, correct?
Yes.
And you mentioned something about a parking lot project and some potential deal with UniSuper?
Yes.
For purposes of the evidence in this case, you've not submitted any contracts associated with any of those deals, have you?
Not to my knowledge.
And to your knowledge, there weren't any contracts associated with those deals, were there?
I was not negotiating with them, so I don't know what stage each of those deals was.
Sorry, again, in relation to, I think this is maybe perhaps the end of my inquiry, some questions posed to you by Mr. Eisenstadt. If we could put up contract 402 and go first to clause 16, I think it's 16, no? 16.2. And this is C22 for the record. All right, if we can go down, please. First of all, the clause, this is contract 402. This is the English translation. That's the railway right-of-way contract, correct?
Correct.
All right. If we go to clause number 2, please. It's a little bit lower, Kelby. Very good. Just, if you could do me a favor and just highlight the entire clause 2. All right. Now, again, this is under a heading section called penalties, correct?
I'd have to look at the...
Here, we're showing it to you. 16th, penalties, do you see it?
Could I request that I see this in paper form, because
Sure.
I find it very difficult to scroll up and down
Not a
on
problem.
something that spans several pages. So I'd really like to see the context of this whole page.
Okay, it's document C22. We're getting it for you now. put the highlighted language up, please? And my specific question is going to clause 16.2.
Okay, I see the clause.
Okay. And in it, you agreed, on behalf of FEG, or FEG agreed, that if it failed to restore the railway and failed to render cargo transportation services under the terms of sections 2, 3, 4, 5, 6, and 13 of the contract, that FEG would agree to, well, it says FEG, or the usufructuary, which would be FEG here, shall surrender to FEGWA the real property where the railway yet to be restored is located, and any such property shall no longer be the subject to this usufruct, correct?
Not correct. May I explain?
No, I'm asking you, this is the agreement you signed, correct?
Yes.
Okay. If we could also go to,
May I explain?
I don't think, I'm not asking you for your legal interpretation. I just wanted to know that whether you signed this agreement and it says what it says.
I'm not going to give you a legal interpretation. I'm going to read the complete sentence. And the complete sentence begins, the usufructuary's failure to begin railway restoration and failure to render cargo transportation services. We did that. And we were given letters by FEGWA to the effect that we did that. That's why I think it's important for me to read that sentence.
Well, you certainly didn't do it for sections 3, 4, you certainly didn't do it for phases 3, 4, and 5, did you?
As I recall, for section 3, there was a specific understanding, and I would have to defer to my colleague Jorge Sen on that, that because there was one customer on the line, and that customer, at least temporarily, was not going to be able to use the service, that we were construed to have complied with that aspect of contract 402.
Well, and documents have been submitted, and the tribunal can assess them on their own. So in relation to, let's go to clause 18. This is my last question. 18, termination. And you mentioned this in your third statement in this case. You had a right, or FEG had a right, I should say, to terminate the agreement in the event, and let's go to number 3, clause 18, number 3. If you can try to highlight the whole thing, Kelby, if possible. And again, this goes directly to a question posed by Mr. Eisenstadt. This, first of all, it's a, and you have the contract in front of you, this is clause 18, sorry, which is titled termination, correct?
Correct.
And we're still talking about the railway restoration contract 402?
Yes.
And in it, you bargained for and obtained a right to terminate the agreement in the event that Ferrovías, FEG, is unable to exercise the conferred right it is entitled to with regards to the railway equipment according to the contract and bidding terms referred to in the second clause of this contract, correct?
Correct.
Or having exercised those rights, it says them, but having exercised them, meaning those rights, it is not able to acquire the railway equipment in accordance with what is established in the 10th clause of this contract, and as a consequence, it is not able to comply with the purpose of this contract for reasons not attributable to it, correct?
Correct.
So you had a right to terminate the agreement if you didn't have the ability to obtain the Guatemalan railway equipment, right? Is that right?
Yes.
But your obligations under this agreement, your obligations under this agreement ran whether or not you obtained that equipment, absent your exercising the right to terminate, correct?
Please repeat your question.
The obligations to restore the railway, you had them unless and until you exercise this termination right, correct?
Since I'm not a lawyer, I don't want to interpret this. I can respond to you as to how the economics work or other aspects of it.
It's
But
okay.
because I'm a lawyer, I think the question is complex enough that I must, as a non-lawyer, say I can't answer it.
That's all right. We thank you for your time, sir. We have no further questions.
Ask one question and follow up to those questions.
Tell us what it is.
Well, it's
I didn't use all my time.
it's not a matter of time. I think it's a matter of keeping some order between who asks questions on what and how long we go, because then the other party may ask questions on what you ask. So it can be endless. So I think we all had a say and an opportunity to ask questions on each other's questions. Thank you. Mr. Posner, sorry, you have a question? Mr. Posner, thank you so much for being here with us and collaborating with us.
Thank you for the opportunity to be part of this important tribunal.
Sorry? Yeah, that we need a little bit of a break for the transition. We'll have, since we are going to adjourn at 4:30, as I announced this morning, we will have a very short break now, 5 minutes. I mean, if literally 5 minutes,
Pit
and
stop.
we continue. Sorry,
Pit stop.
exactly. I don't want to say. Technically.